Hello, and thanks for joining us for our Beyond the Basics, What You Need to Know About Estate Planning. We'll be getting started in just a couple of minutes. We're going to give folks a few more minutes to join. And if you do have any questions, feel free to put them in the chat box or in the question box, and we'll be happy to answer those questions throughout the workshop. And definitely at the end, we'll be taking questions. And we'll get started in just about 5 minutes. Hello and good evening. Thank you for joining us today for our Beyond the Basics, what you need to know about estate planning. We're going to give folks just one more minute to get registered here and get on the webinar. If you do have any questions, feel free to put them in the question box, and we'll be happy to answer those questions for you. Everyone's muted tonight, so go ahead and put them in the question box, and then we'll answer those as we go along, and for sure at the end of the workshop. So today we're going to be talking about estate planning, wills, trust, how it works when you have a home, what is the benefit of having a will or a trust, what is probate and how does that work, and answering some really important questions that can help you all with, planning for your future and making sure you're protecting your assets and your equity and all of that good stuff. So I'm going to go ahead and jump right in here. So tonight it's beyond the basics, and it's what you need to know about estate planning. And it's presented by HomeOwnershipOC and the Elder Law and Disability Rights Center. And we are both nonprofit organizations. I'm the executive director here at HomeOwnershipOC, and we have Andrew Figueroa with the Elder Law and Disability Rights Center, and he will be going into his presentation. Did you want to introduce yourself, Andrew, and tell folks a little bit about yourself?
Yeah, I'd be happy to. My name is Andrew Figueroa. I'm a staff attorney at the Elder Law and Disability Rights Center. I specialize in estate planning, so wills, trusts, healthcare directives, and power of attorneys. I also assist with conservatorship and other probate matters.
Excellent. So we looks like we have the right person here for the job. So, there's subject matter expert. So a little bit about what you're going to learn about tonight, how to protect your assets, your home, and with a will and a trust. Why do you need a will or a trust, and how to avoid probate if at all possible? We'll be providing some nonprofit housing and legal resources at the end of the workshop. And as I said, if you do have questions throughout the workshop, feel free to put them in the question box, and we'll be happy to answer those questions for you. So a little bit about HomeOwnershipOC. We are a nonprofit HUD-approved housing counseling agency. We've been doing this almost 20 years or so. And our mission is to promote and preserve the dream of homeownership through outreach, education, counseling, and financing. So we were started back in 2007 during the housing crisis to help people avoid foreclosure. And we've continued on and expanded our services and have provided over 500 housing events and workshops and educated over 26,000 individuals on homeownership, credit, foreclosure prevention, avoiding real estate scams. And we provide credit, rental, home buying, foreclosure prevention, and post-purchase counseling and education, all at no cost. So you can find out more at our website, which is homeownershipoc.org. And there will be a copy of this presentation on there, probably by next week or so. We'll be putting a copy of this workshop on there. So if you want to go check back in and view it again, it will be available. So, as I said, we're going to be talking about estate planning and wills, and why is this important if you have a home? So, we do a lot of work in foreclosure prevention, and we get many calls with individuals who have a home, or they were living in a home, maybe with their parents. The parent passes away, and they say, now I'm trying to make the mortgage payments, and the mortgage company won't accept the mortgage payments. So it does become a problem if there is no will or trust, because that will, direct the person what to do upon something happening to you, what's going to happen with your home. So we see a lot of problems, and we've just decided to include the estate planning portion in our homebuyer workshops because we think it's really important, and no matter what your age is, that if you want your assets to go to the people that you want to designate, that it's important that you know about estate planning and trust, and you're going to learn about all of that today. So the reasons why you need a will or trust is to control your home distribution. It'll let you specify specifically who should inherit your home. You also can avoid probate. A will by itself sends your home through probate and a court supervised process, but it can be very lengthy and expensive, and it's not really the way to go. A living trust, however, can transfer the home into the trust homeownership during your lifetime, so the property is not part of any kind of probate. And we're going to go into more detail about this. I'm going to let Andrew take all of the hard questions. But the first question we're going to ask you is, did they have a trust? Because that's an important thing. It makes things a lot easier. The other thing, it can protect your privacy. A will can become public record, and so anybody can come out of the woodwork and say, hey, this guy owed me money or whatever it may be, and it may cause problems. And a trust is a private document where you know about all the details of your assets and the beneficiaries, and it's not a public document. Also, you can make plans for the future if you, for some reason, get incapacitated. You can say what your wishes are and what you would like to do. So that's another important aspect of it. And then to manage the assets for the beneficiary, you can do this while you have all your faculties and make all your decisions. And it really gives you the control of how and when the beneficiaries will receive the home or other assets. So it's really important. We think it's really important to do. And of course, it can help you avoid problems in the future. So I myself got a trust done probably 10 or 15 years ago because I deal so much with people with housing problems, and I saw so many of those problems happen because individuals didn't have a trust. So I'm going to hand it off to Andrew now, and he's going to take it away. So go ahead, Andrew.
Right. So, like I said earlier, my name's Andrew Figueroa. I'm an attorney with the Elder Law and Disability Rights Center. And today we're going to be talking about estate planning. The name of this particular presentation is an overview of what estate planning is and setting yourself up for dignity and independence. So before I get into what estate planning is, let me tell you a little bit about the Elder Law and Disability Rights Center. We're really developed or dedicated to community empowerment through education so that you know how to set yourself up and your family up for success. And it's like through advocacy, education, the provision of free and low cost legal services that we ensure that those needs are being met, especially by the elderly and those living with disabilities, or even those experiencing homelessness in Orange County. Because most people now are kind of outliving their savings, as most people have planned and expect to live to about 70 years old. But there are people that are pushing 100, pushing into their late 80s, late 90s, and they're outliving what they planned for. And as healthcare is changing, the housing is changing, and even to this point, senior women are becoming the fastest growing unhoused population. So that's kind of our goal to get there. So today we're going to talk about, okay, what is an estate plan? What documents do you need? And why should you avoid probate court? And how do you prepare for the loss of capacity? So I like to divide the documents up into two groups. It's the during your lifetime and after your lifetime. So during your life, you would want an advanced healthcare directive, a psychiatric advance directive, or a power of attorney, whereas after your death would be a will, a trust, any beneficiaries you have listed on accounts, and there are some alternative tools. Now, for the focus for today, we're going to be talking more about the will and trust. So I'll glance over the power of attorney and healthcare directive. But just so you're aware, the healthcare directive and power of attorney only have effectiveness while you are alive. Once you pass away, any healthcare directive or power of attorney that you've made will expire. And whereas the will and trust will only takes effect after you die, and the trust is a little gray area. Some aspects of it have involved while you're alive. Now, some important things to note is it's my belief and the belief of Elder that anyone over the age of 18 needs these documents. You should talk to your family early, talk to them often. You have to make this topic an okay thing to talk about. Now, we are only going to talk about California law. If you have property out of state or out of the country, you need to consult with an attorney or a legal authority in that state or country. And while you prepare these documents, make sure you also give copies to the people involved. Don't lock them away because a trust that's locked away where no one can get it kind of doesn't do any good. So, why does estate planning matter? As Connie mentioned earlier, it's the main thing is autonomy over your choices. It allows you to make clear what your wishes are for your loved ones. If you're in the hospital and you're incapacitated, you're in a coma, and they're trying to decide, well, you have a healthcare directive, this is what I want. If you've passed away and they're trying to go over your trust, your will, if you have your trust, you avoid probate court because they know what you want. If you're in taking care of any minors, it helps protect minors. It also helps protect everything you've built, your wealth, your home, your property, and protect as an asset for your children or your grandchildren and to pass along. Now, if you don't have a plan, at the end of the day, a judge is going to decide what's going to happen with your things. It's also possible if you receive Medi-Cal, Medi-Cal can come in during the probate process and request repayment for certain services. So that would include some community-based care, or if you're in a skilled nursing facility, they may be able to recover for those. And then on top of all that, you're in probate court, you're going to want an attorney. So you're going to have to pay an attorney their attorney fees. Now, without a plan, your lifetime decisions kind of get complicated. Uh, they'll get expensive. Everything gets slowed down. Especially if you're alive and you've lost capacity, you may be able to get what's called a conservatorship, which again is kind of a drastic measure because it takes your rights away to make decisions it gives to someone else. So the goal is by doing all this is we try to avoid that process. So like I said earlier, we're going to focus more on the will and trust, but I'll glance over the healthcare directive and power of attorney. But we also want to point out that there are some key terms that you should be aware of. The term power of attorney, or sorry, the term durable will be often being put in front of power of attorney. And what that word means is it signifies that should something happen during your lifetime where you lose capacity, you're in a coma, you develop Alzheimer's, you're in surgery, and you can't make decisions. The word durable allows your chosen agent to continue making decisions for you while you're still alive. So I mentioned the word capacity a few times, and different documents have different levels of capacity. But you should be aware, under the law, all adults are assumed to have capacity unless there's been some other form of determination through a legal process, such as a conservatorship. So to make these documents for just a will, you need to understand the nature of the testamentary act. So you need to know you're making a will. You have to understand the extent and nature of your bounty, which is just a fancy way of saying you need to know what you own. You need to understand the relationship with natural beneficiaries, so kids, spouses, your parents, siblings, and you need to avoid the influence of delusions or hallucinations that may affect the distribution of your assets. Now, for a healthcare directive, it's a little lighter. You just have to understand what the nature and consequences of a certain medical decision are. You have to understand the significant benefits, risks, and alternatives. And you have to communicate a decision in some way, be it verbally, non-verbally, etc. Now, trusts and power of attorneys have some overlap. because for both, you have to understand the rights, duties, and responsibilities created. You have to appreciate the probable consequences of the decision. So you want to create a trust. You want to give this person the power of attorney. And you have to be able to evaluate the significant risks, benefits, and reasonable alternatives as well. Now, supported decision making that we have there at the bottom of the list is a bit newer. And you just have to have enough understanding to choose to enter into a supported decision making agreement with one or more chosen supporters. You have to be able to choose who those supporters are, and you have to express a desire to receive help for your decisions. But like I said, it's a newer thing, so the law's still kind of being developed and built up there. Now, as for conservatorships, that isn't here. It's basically you can't have capacity to provide for your own health, food, clothing, shelter, or personal needs. Now we'll get a little bit into the Advanced Healthcare Directive. Some of you may have heard the term living will, medical directive, or medical power of attorney. All these are synonyms for the Advanced Healthcare Directive. So what it basically allows you to choose someone to make medical decisions for you. It also allows you to make medical decisions in advance. So such as if XYZ happens and I'm on a ventilator and that's the only reason I'm alive, then I don't want that. You can make that decision in advance. And the way it works is you have a copy of the document, you want to give a copy to your doctor and a copy to your agent. And the reason you do that is so the doctor knows and your agent, or the decision maker, knows. And there are some key terms that come along with most of these documents, such as principal. This is meant to be you, the person who's making the document. And then agent is the person you've chosen to make decisions for you. And you can include very detailed instructions, such as pain relief, organ donation, even end-of-life care. And like the power of attorney, it also carries that special durable word in it that allows it to survive being incapacitated. And like most documents, it's revocable, which means you can change or cancel it during your lifetime at any point in time, as long as you have capacity to do so. And there are some important connotations. Like I mentioned, you can have an agent. It's also heavily recommended that when you pick an agent, you pick a backup just in case. While technically you can have more than one agent at a time, it's not really recommended, just because in case there's conflicts, there's differences of opinion on what you want. This prevents there from being no action taken. One person has to make the decisions. Additionally, you can also take into account special wishes, such as for religious needs or special care for your burial, and at what time it goes into effect. So as soon as I sign it, or along the lines of in the year 2035, when my doctor says I'm incapacitated, et cetera, et cetera. Now, the power of attorney. So power of attorney is more along the lines for financial decisions. So the power of attorney allows you as the principal to appoint an agent. Now, unlike a conservatorship, the healthcare directive and the power of attorney does not take a power away from you. You can still act on your own behalf. You can revoke the power of attorney at any time as long as you have capacity. Whereas a conservatorship is a taking of your rights and giving to someone else to make decisions for you. Now, you can revoke a power of attorney at any time, like I said, but you have to do it by notifying your agent orally or in writing. You can also do it by creating a new power of attorney. And a power of attorney is automatically revoked when you die, when your agent dies or becomes disabled, or when the purpose of the power of attorney has been fulfilled. That last one tends to be more for temporary power of attorneys, where I'm out of the country and I need this person to sign a contract for me. However, the court can also revoke your power of attorney on your behalf if you lose the mental capacity or become disabled, and if there's a fear of something occurring that you don't. And like I mentioned earlier, power of attorneys carry the word durable in some of them, and that just means it survives you being incapacitated. Now, there's a legal term that involves like when it takes place. I don't like the legal term because it's confusing. It's springing, but I prefer the term conditional. So conditional power of attorney is just when this happens, then the power of attorney takes effect. So when I lose capacity, then power of attorney. When I'm in surgery, then power of attorney. And also power of attorneys have to be specific. They have to give specific powers. And that includes the ability to make or change any of your trusts if you want them to. However, the trust also has to reflexively say that it can be amended by an agent. Now, there are some limits. Medicare, Social Security, and some other federal benefits may not accept them. Social Security is notorious for doing so. If you have to deal with Social Security as a power of attorney, it may be best to be named as what's called a representative payee. And the last note I'll make about power of attorneys is that a bank is required to accept the statutory form. They cannot require their own form over a statutory form. And the statutory form is just a power of attorney that's written out in the law. And it's basically saying anything California, state-wise, has to accept this. So now we'll talk about wills and trusts. So a will, as the image here indicates, what happens to your assets after your death. The will say who will receive your assets and who will make sure your instructions are followed. That person is called the executor. A will can also identify guardians for minor children. So you're able to pick, if for any minor children you have, to go to a specific person to be their guardian. Now, there are some special rules about wills. So a will requires probate, but there are exceptions. So if the total value of a person's assets are under what we call the small estate value, which is $184,500, you can get what's called a small estate affidavit and fill that out, and you can more or less avoid a lengthy and expensive probate process. You also have to keep in mind that people that are expected to receive or named to receive items under the will are called beneficiaries. And I highlight that because that term also applies to trusts. Because trust will also say how and when assets are used and who should benefit from them. However, unlike wills, they can be extremely detailed during and after your lifetime. So it says who will ensure the rules are followed. That's the trustee. And normally when you make a trust, you are the original trustee. And when you no longer want to do it or no longer able to do it, then a successor trustee will come in. That being said, the job of a trustee is a difficult job. And you may benefit from having a person who can fire and replace that trustee. It's known as a trustee protector. Now, another option aside from naming people, such as a close relative, a friend, someone you trust, there are private professional fiduciaries to be that you can name as your trustee or successor trustee. The only thing with that is you're hiring them, so you will have to pay them. Now, it's generally recommended that if your assets are more complex or have a total value of over $184,500, a revocable trust is recommended. That being said, we live in Southern California. Most homes in Southern California are over that limit. And when the law changed recently to increase the primary residence limit to $750,000, that's still under most homes in Orange County. So you would still benefit from having a trust. Now, do know that when you put your home into a trust, you should contact your homeowner's insurance company to notify them. Usually it's not a big issue. However, sometimes some companies can request an adjustment in your policy. That being said, the biggest benefit to a trust is your assets do not go through probate court. You avoid the expense of probate. That is by far and large the biggest benefit. And when you have an executor that goes through the probate process, they have to get approval from the court for everything they're doing. With a trust, the trustee can just carry out the trust directions without waiting for court involvement or court approval. They're able to just, this is what it says, this is what I'm going to do. Now, I
Okay,
mentioned
we have a couple of questions
oh, perfect.
if I can pop in real quick because I think they're related.
Of course.
Um, should we create both a will and a trust?
Yes. So let me rephrase that. It depends. So
Is there a
basically,
benefit, I guess, to doing a will and a trust, or can you just do the trust?
okay, it's a good question, and a lot of people ask that same question. So if you make a trust, typically, if you make it with an attorney, they will also make what's known as a pour over will. And it says that anything that was not included in the trust for some reason, you forgot about it, you got it after the fact, that will says, well, put out all those assets into the trust. Or if for one reason or another assets cannot be added to the trust, because sometimes that happens, then the will says make a new trust that's exactly the same as the old one. So it's meant to try to avoid probate as much as possible and protect the majority of your assets.
Okay, perfect. And then if you have minor children, who would be responsible for their care and managing their inheritance?
Also, a wonderful question. So, when you leave gifts to minor children in California, we have what's known as the California Uniform Transfer to Minors Act, and it dictates that you can't transfer gifts of a certain value. I believe it's $5,000 or $10,000, something along those lines, to a minor directly. So you would nominate what's called a custodian, and the custodian is in charge of managing the assets for the children or for the minors until they reach the designated age, which can be as low as 18 or in California as high as 25. And in that time, the custodian has some discretion in how they want to give things out. Like, for example, if you leave a very like antique, very expensive pair of earrings to your daughter or granddaughter, well, whoever the custodian is can hold it, but they're allowed to like, you know what? It's a special event. It's your wedding. You're going to a ball of some kind, some special event. You can take them out for a little bit, but you're gonna have to give it back until you reach the required age for me to give it to you fully.
Okay, perfect. And you're going to put that in the will or the trust or both?
Normally, whatever the primary document is. So if you have a trust and it would be a part of the trust. If you have a will, typically there's a provision that says the executor will pick a custodian or you will name one.
Okay, perfect. And then what does the agent of a trust do? And is there any difference? Like if
Yes.
between a will and yeah.
Yes, there is a substantial difference. So, like I said, the will only occurs after your death. So the executor's job is to go through the probate process to basically, sorry, let me rephrase that. It's to go through the probate process, get approval, make sure that your gifts are going to the correct person. With a trust, they have a similar job with however you want to leave your items. So my home to my child, they make sure the home goes to that person. My bank account to my brother, make sure it goes to that way. The part that's different is where the trust has a bit of a gray area because part of it applies while you're alive. So you can set it up that you're the primary beneficiary. Everything in the trust is to for your benefit. So the trustee, if you're incapacitated, their job is to make sure they use the assets for your benefit. So if you have medical bills, they need to pay your mortgage, etc. It's their job to make sure that's taken care of.
Okay, good. Well, that makes sense.
Mm. Now, I had mentioned beneficiaries earlier, and I'll just add this as a final note. You don't have to go back, honey. Uh, in addition to creating your will and trust, each account will should get a beneficiary. So what that means is like your bank account, you can name a pay on death or a transfer on death. So when I pass away, this person gets the account. So you can go to each bank, all your investment accounts, your retirement accounts, any of your insurance plans, electronic assets such as email, Facebook, phone, almost anything. And you should be able to find a setting to add a beneficiary and you can add one. If you have a trust, you can even name your trust as a beneficiary. But prior to doing that, you may want to speak with a tax professional because there are certain tax benefits and cons to naming a trust as a beneficiary to an asset. So we're going to be talking mostly about property from this point on. In California, there are two main kinds of tenancy. There's joint tenancy and tenancy in common. So there are different. If you're married, more likely than not, when you bought a home, if you bought a home together, your realtor bought it as a joint tenancy. So what that means is you have equal shares in interest. The both people who own it or all the people who own it were named as owners at the same time on the exact same deed. And then when one joint tenant dies, their share of the property is automatically transferred to the surviving owners. So some examples on your deed that you'll see will probably be jointly as husband and wife, John Doe and Jane Doe as joint tenants with right of survivorship, and not as tenants in common. And the reason why that's important is, like I said, it's an automatic transfer. It's an operation of law. So if you have a joint tenancy with someone and your property is like, let's say you have a joint tenancy with your sibling, when one of you passes away, whoever the survivor is absorbs the other ownership interest. It does not matter if they will their section of the house to someone else, if they leave it in the trust to someone else. It cannot be done that way. Now, tenancy in common is the other type. So this is where you have unequal or equal shares in interest. So such as if Connie and I were to buy a home and Connie had 80% and I had 20%, we would have a tenancy in common. So when a tenant in common dies, however, their interest in the property can pass to their heirs according to their estate plan. So you would see it on your deed as John Doe and Jane Doe as tenants in common, held by them as tenants in common. Now, as I mentioned earlier, we live in California, where most chances you would see joint tenancy because California is what's known as a community property state. So, and as we're a community property state, joint tenancy is typically the arrangement there. Now, community property can be complicated and you may likely require a personal consult because it can affect what you do. However, you can always file a new deed to make a joint tenancy or a community property tenancy in common if you want your interest to go to someone other than the joint tenant. So if Connie and I were joint tenants and I'm like, you know what? I want to leave my share of the house to my nephew. I can file a new deed breaking joint tenancy so I can leave my share of the house. Likewise, when you put your home in the trust, it's my practice at least to make sure joint tenancy is broken prior to that to help just facilitate that process a little easier.
Okay, and there's another question that's kind of related to, so if I have a trust and I purchase a new home, do I need to create a new trust?
That's also a very good question. And no, typically, if your trust is revocable, meaning you can make changes to it, you can update it at any time, you are more than able to add a new property to it. You just have to make sure that if needed, you may have to write an amendment if you want to do something different with that property than with the other one. That being said, if you have what's known as an irrevocable trust, meaning a trust that cannot be taken back or changed without a lot of pain and effort, chances are you might be better off just making a new trust for that property. So it varies person to person on the exact situation.
And they have to remember to record it and put it in the
Yes.
trust, right? So
Yes.
that's
So
another one that
yes.
we often see
Yes.
is
So for some to explain a little easier, at the end of a trust, typically you'll have what's called the schedule of assets. It's a list of things that are supposed to be in the trust. Now, just because it's on the list doesn't mean it is in your trust. You can think of it kind of like your shopping list at the grocery store. Just because you're going to buy, or just because you're supposed to go buy tomatoes doesn't mean you will, because if they're not good, they're not good. That being said, if when you're checking out and you see a candy bar at the checkout station and you're like, you know what, I really want that Hershey's bar, and you buy it, even though it wasn't on your list, it still becomes part of your trust. So what matters is that the assets are in the name of the trust. So like when I said about recording a deed, it is about making sure the deed is recorded in the name of the trust. If you have a bank account, making sure the account's in the name of the trust. And that's what puts it in the trust beyond just being on the list. But your list will at least show that you intended to put it in the trust in case it was forgotten for some reason. And it makes it easier in case when you pass away, it's just not in the trust for some reason. It wasn't properly recorded, whatever. It allows the executor trustee to make a better argument that it should be part of the trust.
Excellent. Thank you.
Now, if you don't have a will, trust, and or beneficiary, that's what we call intestate, which is just a fancy Latin term meaning without a will. And it just says that you're going to pass away, or you are going to pass away. Your object's going to be passed in the manner prescribed by law. So what our chart here kind of describes the most common situations. If a person passes away and they have a spouse, but no children, parents, or other relatives, as you expect, everything goes to the spouse. If no spouse, but you have children, everything to the children. If you have a spouse and one child, your spouse will get all the community property, but half of the separate property, and the child gets the other half of separate property. Now, if you have a spouse and two or more children, the spouse will get all the community property and 1/3 of the separate property, whereas the children get an even split of the remaining 2/3. Now, if you have no spouse, children, or parents, but you have siblings, everything goes to your siblings. Now, there are some other tools if you're unable to do an estate plan. There's the transfer on death deed. The only thing I would warn against about it is that it's less flexible and there has no backup plan. So, for example, a trust allows you to make contingents. So I leave this to my nephew, but if my nephew can't accept it for whatever reason, then to my niece, then so on and so forth. For a transfer on death deed, it's very inflexible, so it doesn't allow you to do that. And additionally, if there's anything on the transfer on death deed that does not match up exactly right, it may be invalidated and that transfer cannot occur. So, like, for example, if I leave it to my nephew and niece, but my nephew predeceases me, well, my niece can't inherit because it's not how it says on the transfer on death deed. Now, there is a new process that I mentioned earlier for the petition to determine succession to real property. And that process is basically, it says, if you have a home value that's $750,000 or less, you can go through a simplified probate process to transfer that. But as I said earlier, we live in Southern California. Chances are your house is valued more than that. And finally, as I mentioned before, there's a small estate affidavit, which it can be filed about 40 days after the death of the person, mostly because it takes about that long to get the death certificate. And it applies to $184,500 estates or less. It doesn't really apply to real property because it tends to push things above that limit, but you can avoid probate court. Now, these tools may help you avoid probate in certain cases, but they're not a full estate plan. So if the value of your estate or beneficiaries aren't updated, these plans can fail, and a trust will provide you more flexibility and control. I think we had some questions.
Yes. There was, is it correct that you would not put a limited liability company in your trust, LLC?
So that is an intriguing question. It is possible to put a company inside your trust. Whether it's recommended or not, it depends on the person's specific situation, what their goal is. But to do that, you would want to speak with an estate planning attorney that has a lot of specialized knowledge with business as well to do that effectively. But it is technically possible.
Okay. And then, yes, we are recording this and we can send it out. It's also going to be on our website. So, we'll send out the link to the recording, but you can also view it, in a couple of days, probably by next week. It'll be on our website on the, events page. All right.
Oh,
Yes. So back to you, Andrew.
oh, back to me. Cool. Goody. Uh, so now an overview of what to expect. This chart's a nice little breakdown of what you can expect for anything that for any real estate, bank account, electronic asset, and personal items. If you don't have a plan, chances are you're going to go through probate. And chances are Medi-Cal recovery will enter because you've gone through probate. Now, for if you have a will and your total assets are over that magic number of 184,500, chances are you're going to go through probate, and Medi-Cal recovery will apply if they can come in. Now, for real estate, if you don't have a transfer on death, or sorry, if you do have a transfer on death deed, probate may not apply. Medi-Cal recovery cannot come in. But like I said, it's a little risky because it has to be exact and the situation has to match up exactly. Now, for your bank accounts, if you have your beneficiaries named or your will assets are under 184,500, no probate, no recovery. For your electronic assets, if you have a beneficiary named or your will, you have a will and your assets are under 184,500, no probate, no recovery. For your personal items, if your will is there and your assets are under the magic number, no probate, no recovery. And across the board, if you have a revocable living trust, you will not enter probate and there will be no Medi-Cal recovery. I will put a little asterisk on that. If people challenge the trust for some reason and it becomes a big fight, it may enter probate at that point in time. But the main goal is to avoid it by doing it, which is what tends to be honored and followed. Now, I will give another little warning for your retirement accounts, such as your IRAs, 401ks, your life insurance. It can pass by a beneficiary designation. And in our experience, it tends to not be best to name a trust. And in that regard, if you don't have a beneficiary designated, it may end up being paid out to your estate, and the probate may then be required.
Yeah, we had a question come in. If I have a property outside of the United States, can I include it in my will or trust?
That's a good question. Typically, in my experience, no. You may want to speak with an attorney or a legal professional in that country to kind of review the rules to see what can and can't be done. You may be able to reference the property in your trust to say, like, just so a heads up, I have another property in Cancun, and I want to give it out per the correct laws of Mexico. Please find that document located in XYZ. So like, you can refer to it, but you can't include it in the trust in California.
Mm-hmm. Okay.
Now, just for everyone's further information, these are the legal services in Orange County. You have the Public Law Center, the Community Legal Aid for Southern California, and the Veterans Legal Institute, as well as my organization, the Elder Law and Disability Rights Center. Now, here are some other resources, such as the California Department of Aging, the Orange County Office on Aging, the Orange County Council on Aging, and so on and so forth. Uh, so the Office on Aging is ensure that Orange County's older adults experience a high quality of life characterized by independence, safety, health, transportation, appropriate nutrition, and social activity. Whereas the Council on Aging is about promoting independence, health, and dignity of older adults through compassion, education, and advocacy. And if there are any other questions, please feel free to ask. I'm more than happy to answer them.
Excellent. So let's see. I think we have a couple of questions. Um, so let's say somebody is incapacitated and they're in a nursing home. And would they be able, obviously they're not able to sign any documents. So if they don't have a will or a trust, what would the family do at that point if they had assets?
So at that point, it's a little more complicated because typically you want to have capacity to make those documents, but there are ways around it. So as I mentioned earlier, the conservatorship process, there part of the conservatorship process is you can go. There's two, shall we say, sets of powers: person and estate. So the person powers is where they're going to live, etc. The estate powers, however, if you get those powers, you can request a substitution of judgment, is the term, from the court. And what the court allows will then allow you to do is make an estate plan for that person. The only caveat there is even though you can make an estate plan, including your trust, you still have to submit it to the court for approval. Their concern is all about fairness. And if there's no estate plan, they're going to try to ensure that you comply with the kind of those rules I showed you earlier if you don't have a plan. So, for example, if you have 3 kids, they're going to try to make sure that, well, just because this kid number one is the conservator, they're not going to get 90% or 98%. The other 2 kids are going to get 1% each. They're going to try to split it up so every kid gets 33%.
Mm-hmm. Can me and my husband have one will and trust together to give everything to our children, or do we need a separate one for each of us if all our property is in both our names jointly?
Okay, so a trust, you can make what's called a two settler trust. And what that does is allows 2 people to make the trust. It's normally used for married couples. However, the power of attorney, healthcare directive, and the will are independent documents. So you have to have your own.
Okay, that makes sense.
Mhm.
And then what is a common cost for a revocable living trust?
So it varies from attorney to attorney. Each attorney will charge a little bit different. If you're going to speak with an attorney who's a specialist in estate planning, they may charge you a little more. I know personally, I believe the range for a full estate plan for a married pair, I believe it goes from 2,500 up to 8,500, somewhere in that range.
Mm-hmm. And are there any low cost places where they could get some information or put something together?
So it you could always reach out to my office at the Elder Center. And if you're income qualified, we have what's called a sliding scale service. So we will charge you a reduced rate, but you have to, like I said, you have to be income qualified. Uh, Unfortunately, for other options, you will have to just look around till you find an attorney that fits you. But I will also tell you at the end of the day, while it can be expensive in the short term, it's going to be far less expensive in the long term because when you go through probate, we've talked about the expense. To clarify, the expense isn't your family's expense; they're not paying out of pocket. The money is coming out of your estate to pay for that probate process.
Okay, I gotcha. Um, uh, let's see. And if the property goes into foreclosure, but the lender does not notify that one of the parties of the foreclosure or the auction date, what benefit does the trust provide in this situation? Or does it provide any?
So
Um,
the trust is all about protecting your property, and you can only give away property that you own. So if you lose it because of a foreclosure action, then you can't give away what you don't have. That being said, if they didn't properly notify you, you would may want to speak with a personal injury or even a real estate attorney to figure that out. The trust won't be able to do much in that specific situation.
mhm. And if I have a will and a trust, will I still need to individually inform my job and bank of like who the beneficiary is for the assets, like a 401k or retirement account?
Yes. I would caution you against informing your job. You would just have to tell the holder of the 401k or retirement accounts. So I know, what is it for the teachers in California? They have what's called, I think, CalSTARS is the one holding their pension. You would inform CalSTARS of your beneficiary choice, not your job per se.
Mm-hmm. And you said something about a bank account too, that the we could list a beneficiary, but does the bank account have to be like in the name of the trust?
No. So
No.
if you have a personal bank account and you name the beneficiary of that personal bank account as my child, when you pass away, the bank will essentially ignore your will or trust. They don't care. They have a process where it says beneficiary, so they're going to give it to that person. So if you do that, it's not strictly required to put it in the trust. It's just you may just want to open a trust account for any monies earned from the trust, such as if you have an asset that's money generating or income generating, you can protect it with trust.
Okay. And then say I pass away and I have a 401k and it's to go to my son. Are they going to contact the son and
Yes.
say, hey, yeah, like, because I don't know how the son's going to know. Well, hopefully they have a copy of the documents, but
Yes, that's the hope that they're notified in some
maybe
way.
not.
But the beneficiary, when you name a beneficiary, whoever holds the account is supposed to inform that person and keep them apprised of the transfer process.
Okay, perfect. And then you mentioned about the deed upon death document. Is that something that you can just file on your own, or do you have to have an attorney do it, or
You
you know,
can
what's the
you can
process?
technically do it on your own. Again, my only caution with doing the transfer on death deed is that it has to be so particular and so exact. So if the situation that arises when you pass does not match exactly what the transfer on death deed says, it may be invalidated, and it's it's a little too gambling for my personal taste, but people have had success with it in the past, so it's up to personal preference.
So the best thing to do is to have a trust
Yes,
in that situation so that it can have all the different scenarios. If this person's not available,
yes.
then it would go to this person and all of that. Perfect. Well, thank you so much, Andrew. I think we got through all of the questions. I thought this was really informative, and I appreciate all of the folks who joined us today. As I said, we're recording this, so we will definitely have a recording available to you all, and I can send that out to you. And then just give us a week or so, we'll have a copy of it up on our website, and you can go back and reference it or send it to your friends and family. And if you do have any housing questions, feel free, like those foreclosure questions, you can always come to us and we can help you try to navigate that situation, and refer you to some of our legal partners here, uh, like Andrew and some of the other legal service providers, and see if you can get some help in that way. But I hope you all found this very informative. I know I did. And thank you again, Andrew. Appreciate you joining us today. And thank you all for all of the participants who are here today. You guys had some really great questions. Feel free to reach out to us if you have additional questions, or reach out to Andrew. He's available to assist as well. All right. Well, have a great rest of your evening, and thank you again. Thanks, Andrew.
Not at all.
Okay, have a good one.